TR 617, State of Kansas versus Abel Estrada. Paul E. Dean for the state and Mr. Estrada appearing in person and pro se. The defendant was found guilty February 14th, 2025, ordered to pay scheduled fine in 108 within 15 days. And what have you done about that, sir?
I submitted the notice to appeal.
Okay. And have you done anything to perfect that appeal with the Kansas Court of Appeals?
I'm waiting. I literally just spoke to the court record.
All right, guys, buckle up because this courtroom moment begins unlike most. Tamika Slip walks in, not anxious, not defeated, but smiling from ear to ear. The judge greets her warmly, recognizing her immediately, and the mood lightens in a way rarely seen in a court of law. With a clear, sincere tone, Slip says she's doing well, and even shares she's feeling great simply because she's around familiar faces. This is no small moment. She's in court for 5 active cases, yet her energy radiates positivity. There's a special connection forming between her and the judge, something deeper than routine. Her defense attorney quietly prepares beside her, while the judge, curious, checks the stack of cases with a bit of humor. The tension, typical in criminal courtrooms, is replaced with something gentle. And as the clerk confirms her cases and charges, it's clear this isn't going to be a normal proceeding. This feels different from the start, personal, real, and deeply human.
Next thing is we're just waiting for the plea.
All right. First of all, I'm not making if Mr. McClendon has not withdrawn, I'm having him do so now because we do not, to my knowledge, pay for appeals of illegal tags. You'll need to be responsible for that yourself. And it's not enough just to file the notice that you intend to do it. You need to actually do it. So are you going to be representing yourself or hiring an attorney on that, Mr. Estrada?
I would like to get an attorney.
Well, you're going to have to hire one because throughout the trial, you kept insisting that you, if I'm remembering correctly, you didn't want an attorney. Isn't this one where I made Mr. McClendon stay on as kind of a backup counsel?
That's correct, Your Honor. He was essentially became standby counsel, and the court granted Mr. Estrada basically special consideration on this matter, as this is not even an offense that's eligible for court appointment, as it does not carry a sentence that exceeds 6 months.
Oh, yeah, yeah.
And I thought the court, maybe I was going to double check the journal entry. I was thinking Mr. McClendon, maybe even on the last journal entry, had been allowed to withdraw, but there was delay in me getting the paper, those journal entries to the county attorney's office because I had a few to complete after that day. So they had not all been emailed in. So I think they might still be in the process of being e-filed, because then the following week as I recall correct, I didn't travel to Greenwood County because of all the snow. Okay. I did my meeting with the commission via Zoom. So, but today the court's ordering that Mr. McClendon is withdrawn. Mr. Abel directed or advised he should perfect his appeal.
And I'm going to set his pay or appear over 30 days to see if, and remember, you were to pay a $15 or $158 cash bond. Did you do that when you filed your notice of appeal?
I'm sorry. Can you repeat that again?
I had ordered that if you appealed, you had to pay a $158 cash bond. Did you pay that appeal bond?
No, I didn't, but I was trying to get a waiver.
As the court continues, the judge begins reviewing Slip's 5 cases, and the atmosphere remains unexpectedly compassionate. Case by case, the clerk confirms each charge, from trespassing to disorderly conduct, and we can see that this isn't about just one bad decision. It's a complicated history. Yet, Tamika stands tall, calmly listening, even correcting a minor detail with respect. You can feel how invested the court is in getting this right, not rushing her, not judging her for the past. The judge, with careful deliberation, starts mapping out how to resolve all of it today, trying to consolidate and give her closure. Her attorney and the judge both agree, they want to handle this with care. There's an underlying message here. She's not just a defendant, she's a person. And everyone in that room seems to recognize that. The tone remains warm, and Tamika's soft voice reflects someone who is genuinely grateful for how she's being treated. We're watching something rare, justice done with heart.
No.
Well, I would deny any appeal bond. Mr. Abel, the facts in this case were very straightforward. You'd made up or bought a made up alleged tag that wasn't even close to being a legal tag. We spent a lot of money trying it, and I say a lot of money because I made the defense attorney stand by, even though you didn't want an attorney. Now you say you want an attorney to appeal it. Well, I'm sure not going to appoint one to appeal it. And if you cannot even afford your $158 appeal bond, I'm wondering how you're going to afford your attorney if you can even find one to take this kind of case on appeal. I would venture to suspect that it's never been done before, but if you think you can get it done, you're welcome to. But I am proceeding that until that appeal is perfected, you still owe $158 fines and costs, and you need that to pay that appeal bond. So I'm going to review this in 30 days, and you better have it all figured out, or you better have it all paid.
I actually started the process, and I send the appeal notice, and I actually send I requested what's it called? The report. Oh, the journal entry from Mr. Dean office, but I haven't got it because the journal entry reflects $50, but I never got it. I never seen the charges or the journal entry. I'm trying to get all the information in.
That's all great, Mr. Estrada. The journal entry is being filed. Your Honor, I don't know that at least the state's not particularly interested in his steps to appeal. That's for him to figure out on his own. I do have one item to correct on the record, Your Honor. I think probably it's proper to note that Mr. Estrada was wanting counsel. However, both court-appointed counsels, Mr. Paul and Mr. McClendon, both believe that Mr. Estrada was also wanting them to violate their oath as an attorney and make arguments
that is incorrect.
Don't interrupt, please.
And make arguments in violation of both the U.S. and Kansas Constitution. Was the specific statement both the attorneys made to this court.
Yes. So,
that was all. I just wanted to correct it because he was asking for an attorney, even though, quite honestly, the case doesn't qualify for court appointment.
Oh, thank you for correcting the record.
The court still did grant him that an attorney, but the attorney's based. Mr. McClendon became standby because he believed that the arguments were not supported and were in violation of his oath.
Now things take a more emotional turn. Tamika openly shares that she's autistic, a revelation that instantly reframes how we see her presence, her reactions, and her heart. She's not using it as an excuse, she's simply explaining who she is. The courtroom pauses. The judge listens with intention, showing no sign of irritation or dismissal. It's not just respectful, it's validating. The vulnerability Tamika displays would make anyone reflect. She asks for clarification with humility, making it clear that understanding the process is important to her. And instead of brushing it off, the judge responds gently, guiding her through every step. This isn't just about her charges, it's about her right to be heard, understood, and treated fairly, regardless of mental health or neurodivergence. In most courts, people like her get lost in the shuffle. But here she's seen. She's heard. And it makes all the difference.
I just asked for the basic fine. What I refer to as basic fine, it's not really a scheduled fine, but it was $50 because he did actually have it. He just refused to
put on his car.
Display it.
That's right. He refused to put it on his car, put on that cardboard.
So despite all the rigmaroles, I treated it just as any other case.
Okay. All right, Mr. Estrada, we're going to make you come back for another pay or appear in 30 days. Missy, when is that?
March 28th at 11 o'clock.
right, March 28th, 11 o'clock. We're going to review this and see if you've paid your case and moved on, or if you're going to keep fighting it and you never mind. All right, but I understand, Mr. Estrada, what is it you're appealing? The fine and court costs, or are you appealing the verdict?
I'm appealing the
Oh.
verdict.
Okay. And you want to maintain your argument that that cardboard tag was legal. The tag that you made was legal.
Yes. That is
Okay,
correct.
all right. I just wanted to make sure I knew what we were doing here. All right, I'll see you back here March 28th at 11, unless you paid your $158 balance. Thank you, sir.
Yeah, I just wanted to know, where do I get the report, the journal entry from Mr. Dean?
It'll be with the court. Look at the
The
court.
clerk of the district court is the keeper of journal entries.
You mean the court record?
The court records are all through the clerk of the district court.
Okay, thank you.
They're the public record holder. Yes, sir. And that's about all I can advise you. I'm not going to help you practice.
The court moves into the plea agreement, and Tamika's presence remains steady, still smiling, still respectful. The judge explains the charge she's pleading to, a disorderly person offense. It's the kind of charge many people don't understand, but Tamika listens closely, nodding carefully, showing she wants to understand every word. The judge's tone remains even and calm as he explains her rights: to trial, to remain silent, to testify. And each time she responds with a clear yes or no, always polite, never defensive. Even when asked if she's under the influence of drugs or alcohol, her answer is clean and confident. This isn't a woman trying to escape responsibility. This is someone who genuinely wants to do things the right way. The courtroom, often cold and procedural, suddenly feels like a space of real accountability with compassion. It's a rare thing to witness, but incredibly important.
I mean, I can place my status on the record if you like.
Yeah, hold on one sec. Yeah, I'll get to you 1 second. I need to look over some things. Are you
Yes.
representing yourself?
No, sir, I'm not representing myself. I'm presenting
Okay.
myself.
Okay. I mean, do you have is a court-appointed attorney going to be speaking with you, or are you going to have a retained attorney?
No, sir.
The calling case Tom King 25 William Boyd 00474 in the matter of Roman Curtis Campbell. Mr. Campbell, would you please state your name for the record?
Yeah, I like to state
Just tell
my
me your
name.
name. Yeah, go ahead. Yeah, all I have to do is say it.
I'm Roman Curtis Campbell, a natural
Oh,
person, full life.
Okay, let me ask you this question, Mr. Campbell. Let's try not to talk together. I mean, I'm going to allow you plenty of time to talk because I have to. But are you representing yourself here today? You don't need an attorney, or you want an attorney?
No, sir, I'm not representing myself. I'm presenting myself. I don't need
Okay.
another man to present.
So are you presenting yourself? So you don't want an attorney, you're presenting yourself here today. Is that correct?
Yes, sir.
Okay. All right. Thank you, sir, for that.
You're welcome.
You're charged with domestic violence, as I've indicated. MCL 750.81. It carries a maximum penalty of 93 days in jail, possible fines of $500 and/or both, not including any court costs. I am going to enter a plea on your behalf of not guilty on this offense. You will be given an additional, and you're also charged with refusal for collecting fingerprints and data, which the court is ordering that you do that. As I've indicated, I'm entering a plea of not guilty on your behalf for this matter. I'll indicate that you're self-representing at this time as well. I do have some other conditions for you before I set bond. You're not to have any direct or indirect contact with Marissa, Maurissa Smith. You're not to return to the premises known as Celeste Road.
That's my home.
Yeah. I'm gonna keep going, and then I'm gonna take all your questions at the end. So no problem. It's not. Just hold on to that question. That's all. You're gonna have plenty of time to talk at the end. So do not return to the premises known as Road, West Bloomfield. You will not assault, beat, verbally harass, intimidate, or threaten any potential witness. This person may appear for all court proceedings. Do not leave the state of Michigan without permission of the court, and immediately notify the court in writing of any change of address or phone number. You need to provide the court with a valid address within 24 hours of your release. Do not leave the state of Michigan without permission of the court. You will not possess any firearms or other dangerous weapons. You shall refrain from using alcohol, any form of THC, illegal drugs, or using any medication. You must contact pretrial services within 24 hours of your release. That's at the 48th District Court in Bloomfield Hills. Pick up no new criminal offenses. And I understand you're self-representing yourself here today. The court will set a bond in the amount of $1,500 cash surety, no 10%. Sir, do you understand your bond, what I read off to you, your bond conditions?
Yeah, I understand all of that, but all of that.
Okay, now I'm gonna take your questions right now. Thank you very much. So what questions do you have for the court?
Can I place my status on the record, sir?
Absolutely, sir.
Okay, I'm Roman Curtis Kempiel. I'm a natural person in full life, in propria persona, sui juris serveritis, my nationality and citizenship being Moorish.
As the plea is entered, Tamika thanks the judge, and what happens next feels like something straight out of a human drama. The judge asks what she wants to say before sentencing, and she doesn't beg, she doesn't justify, she blesses him. Yes, blesses him. She says she prays for him because she knows his job is hard, and the entire courtroom falls silent. That kind of gratitude, that kind of emotional honesty, is something you can't fake. It's not manipulation. It's not performance. It's real. The judge visibly softens and admits he'll miss her. Even her attorney says, she's a wonderful person, which is rarely said in open court. What we're witnessing here isn't just a legal resolution. It's a spiritual moment, a human connection between judge, attorney, and defendant that rises above paperwork and criminal codes. And Tamika, once just another name on a crowded docket, becomes unforgettable.
Sovereign citizen gibberish game?
I'm not a sovereign citizen, sir. I'm not a sovereign citizen.
You sound like one.
Well, I'm not.
All right. I assure you I have jurisdiction. So we've got a court date set before Judge Satterfield. I'm going to appoint James Watts at this point to represent Mr. McLaughlin, noting he's made a request to represent himself. Again, that's to be a matter taken up fully before the assigned judge, Satterfield, at the hearing date on April 7 at 2:30 or some later time. And the court will set a $5,000 cash or professional surety bond, though obviously it's not going to affect his current incarcerated status. All right. Bond set, attorney appointed, court date established on Judge Satterfield's calendar. Anything else we need to address at this time, Mr. Sweeney?
No, Your Honor.
Mr. McLaughlin? Apparently not.
Yeah, you need to address a point of order. As a
I've
first
addressed
point of
all
order
of the
in
points
court
of order that I'm
first
inclined to
thing
address
you must
today.
do is establish
Mr.
your
McLaughlin.
jurisdiction.
The McLaughlin matter is currently in recess, and we'll move on to another matter on the docket.
I object to moving on in any manner.
Objection noted and overruled, Mr. McLaughlin. All right, let's move
Request a
on.
copy of- I
Thank
request
you
a
to
copy
the
of the
Hutchinson
minutes,
Correctional Facility.
transcripts, these proceedings.
We can go ahead and take him off the meeting at this time.
The sentencing itself is swift but layered with understanding. Tamika's attorney recommends a time-served sentence, acknowledging her extensive time already served in DOC custody, and the judge agrees without hesitation. But it's more than just ticking a box. The judge looks her in the eye, tells her he wishes her well, and gently urges her to stay out of trouble moving forward. It's firm but not cold. He doesn't sugarcoat anything, yet you can tell he genuinely wants her to succeed. It's that rare tone, serious, compassionate, hopeful, that makes the message land. She responds with thanks and holds on to her smile,